Hi guys, welcome to another episode of Malcontent Corner, the corner where I hope to share with you the various tips, tricks, and secrets of things that I have learned in the course of my daily life. So here we are, episode 4 of Estate Planning 101. Hopefully you watched my first 3 videos where we covered such things as last will and testaments, living wills and advance directives, and the various power of attorneys that there are out there. Now, in my mind, those are the very 3 minimum things that you need with regards to your estate planning. I'm not saying they are the only ones, but they are the very minimum. And because I'm not a lawyer and the matters involving estates vary from state to state, I always recommend seeking out the help of a legal professional with regard to any estate planning. Now, with that being said, there's a couple of more vehicles I wanted to inform you of. This is more of an FYI. I have no personal dealing with them, but I know about them, so I thought I would share them with you. Now, before we get into that, let me back it up and kind of tell you what will happen in the event you pass on. Typically, once you pass on, your will and estate will go through a matter of probate. And that's basically a probate court. And all that is that a lawyer will bring the contents of your will up to the court, and a judge will either take the will as being valid and appoint the executor, who can then deal with whatever is written in the contents of the will. Now, there's a couple of negatives about going through probate. Now, I don't want to scare anybody here, but I'm just letting you know. The cost involved in probate can be upwards of 5% in dealing with the probate, and that's due to lawyer fees and court costs. Also, it can take months to sort a probate out. So there's a little bit of a time lag there. Now, that's not to say that that's the only negative, but I'm just making you aware that there are typically costs involved, and there are also typically a time lag there. Now, let's say you don't want to deal with that. Now, if your holdings are large enough, and if it's viable to you, again, seek out a lawyer. You may want to look at putting your items in what's known as a revocable living trust. My understanding is, in a revocable living trust, you put all your property and business holdings and everything in there, and you are the trustor, and you appoint a successor trustee that, upon your death, will divvy up all the everything within the trust as you have written out in setting the trust up. Now, that does not negate the need for a will. You should still have a will, because let's say you get some property or some business holdings and you haven't had time to put them in trust. The courts will still need to know what to do with anything that is not within the construct of the trust. So it does not negate the need for a last will and testament, but what it does do is, number one, my understanding is that the trust can usually divvy up the property within weeks as opposed to months, and also that all the dealings within the trust are not open to public disclosure. Most people don't worry about it. It's not typically a big deal, but your last will and testament, the contents of it are public record. My understanding is that the creation of the revocable trust is public record, but the contents within there is not. So there you go. Now, there is a negative to that, always is. Number one, it takes more paperwork to set one up, and number two, it does cost money. Now, is that advantageous to you? I couldn't tell you, but my understanding is it is advantageous for people who have blended families, who have multiple property holdings, especially in various states, as well as any business holdings. So it may apply to you. And it's not a one and done. You can change it however you see fit while you are alive. Put property in, take property out, add people, subtract people. However you want to change it, it can be changed. So just, again, it may work for you. Now, the other thing is a transfer of death deed, otherwise known as a TOD. And basically, it's much like a payable upon death note, in that when you pass away, your property will immediately flip over to ownership of whoever you have stated. Typically, you will have one person listed on there and an alternate in case the first person you listed is not available, aka they're dead or can't be found, to take possession of the property. Now, there's advantages to that. As with probate, the costs can go up depending on the size of the probate. So it's a good way to make sure, number one, that a piece of property will immediately flip over to a person, and it takes it off of the load of probate if your estate has to go through probate court. Now, there are some caveats to that. Number one, not every state has a TOD. I don't know how many do, but I want to say it's maybe about 15, maybe a little more, maybe a little less, but not every state recognizes a TOD, and because of that, a TOD can only deal with property in the state the TOD is written. So in other words, if you live in, say, Oregon, you cannot TOD property in Florida. There you go. There is typically, once again, cost involved in that, and the TOD, my understanding, has to be recorded at the land use department at the county level. Again, as with everything you have probably learned with regards to estate planning, it does vary from state to state. But that may be something you want to look into. Who knows? So anyways, those are at least the two vehicles that I know of. Hopefully you can apply them or not. That's not to say these are the only ones, but these are the two that I am aware of. As always, thank you for listening to me at Malcontent Corner. I hope everything I've informed you about here is of use to you. If you like this video, give me a thumbs up. If not, give me a thumbs down. But as always, thank you for listening to me, and I hope to see you back again here soon. Until then, take care, and we'll catch you on the flip side.